this evening. We ask you to open up our minds and our hearts to the law, because all of this law is your law. We ask this through your Son, Yahushua. Amen. Do we have any announcements this evening? Okay, go for it.
Okay, as I announced last week, folks, I did get the paperwork from the tape that Tom Shaw had put out several years ago. And he is a CPA and an expert witness in court in finance matters for 10 years or better. I do have the paperwork, but I'm going to ask a donation of about $1 each. There's 3.5 pages. And also in September, October, American's Bulletin of this year, there is an article called, "Is Your Local Banker Involved in Check Kiting, Mail Fraud, Racketeering?" And I suggest everybody get a copy of it and read it, because they tell you on the last page of the article that we need people to start raising this flyer, sending it to your congressman, governor, senators, state legislators, mayors, local sheriffs, and judges. Send them copies of this article, and we may get America back sooner. That's all I have to say. Thank you.
So I've been coming here some time, and so I wanted to speak out on my dilemma and tell you what I've learned since I've been here. I had to go to court last week and face the judge on a housing violation. And I remember what Victoria said in her program that I went to. And she said the judge was like an inanimate object. He just sat there and he didn't really think. So I did what Jack suggested, and I told them that I didn't want to argue. I wasn't in discord with the court, that I was in accord with them, and I would go along with their recommendations in improving my property by paving the driveway. That's the only thing that's wrong. Where the people park, it's not paved. And I said, if on condition that you prove to me that I'm not exempt by the grandfather clause, because people have been parking there since 1950s, way before I came. And they have me in court for this. And according to their notes, I'm a criminal because it's not paid. So I said, Your Honor, if you would tell me if I'm exempt according to this clause. And I thought I'd get an answer. And he looked at the inspector and he said, well, what about it? Is she exempt? And he said, I don't know. I have to ask my boss. So I've got to go back next month for them to find out if I'm exempt. In the meantime, the lady from the court called me, and she told me to plead. I had pled not guilty. She told me to plead no contest because they would put me in an SIP program, which I don't know what that is, but I'm sure I'll find out, and try to find some funds for me to pave this lot, and then they would dismiss my case. So I know I'm not arguing. I told them I'm not arguing with them, although I think I should be exempt. They didn't have an answer for me.
It's good to be able to go back again because it's their show clause. Let them come and testify. And the information to not plead not guilty was absolutely correct. Because when you plead not guilty, you say you want to argue facts, so you're doing the opposite of what you told them you were there not to do, which was not to argue facts. So they were absolutely correct. Okay, so see, when you go in there and you act to try to remedy, and you're in peace mode, everybody wants to help you. So, good for you. There you go. Yeah, he was smiling when you left. If you can make a judge smile, you can usually leave the court smiling too. Yeah.
Since we're talking about cases, I guess I wanted to share my traffic ticket that was back in, I'd say a couple months ago. A while back. Was in court. It must have been about 200 people in court. It was like a packed sardine box. in downtown Cleveland there, and I think it's the 3rd floor. My turn was up. And the funny thing about it was, I was really observant because it took about 20 minutes before I came up, and I'm looking up there, and I see the judge sitting there, and I see a flat panel screen on the right, and there's another lady standing next to the judge, and there's another flat panel screen, computer screen, and I think maybe that's the bailiff. I don't know who's standing next to the judge. So she's looking on there, I guess, to see who's coming up. On the left side of the judge, sitting down, there are, I guess, those folders that are color-coded. I guess they're numbered or what. They're on the left side. So I can see there's some activity up there. And then right below her, bottom right of the what do you call her? She sits on a podium there, bench, whatever. Right side is another desk, another person there, I think, in a I don't know who that is, but it's in uniform. So what happens is that I came up there and she asked me your name, and I said, I'm here to have a PR bond in my name, and I didn't finish even my sentence, so she goes, I need your name. And she goes on and says, I can't not give you anything if I don't know who you are. I have all these cases here. Who are you? And I said, she asked me again the name, and I go, I am not to give testimony that might incriminate me. And
was she smiling?
Well, she just looked with this absolutely deer headlight blank, and then she looked at me and she said, you may go. I walked out, and the bailiff was out there after about 5 or 6 minutes and approached me. There was somebody else that was with me to help me out in case things went bad. Because I filed paperwork before I went into court, the procedures that need to be done. She asked me, she goes, that paperwork you sent us what was all that about? I mean, we can't do anything unless we have your name. I'm thinking, how do you know it was my paperwork in the first place? To myself, you know. So I look at my friend, and my friend made a comment to her, and that was it, and we walked out. And I kept looking back to see if she's going to follow us and ask us for something, you know, because I know she's on the clock until she clocks out. I could be across town, and she gets my name, it's over, you know. But a certain time went by, about 90 days, because I heard you said to check the record every 90 days. So I pulled a journal out from downtown. I went down there, pulled a journal, and lo and behold, I look on there, and there's what's the other name for a warrant? Capias. And I'm looking on there, and there's a capias out for me. And I found this out because I went back downtown to the 13th floor, which is housing, and I met someone who could help me out because I was looking for some paperwork. And he pulls up, he says, there's a capias out for you. And I go, what? Let me see. And I look on there, he prints it out, and it says, never appeared in court. Mm-hmm. And I'm like, wait a minute, I was in court.
Prove it.
So we sent papers out again, and it says on there something that it was discharged or dismissed, I think, or something like that. But there was still a capias out. Mm-hmm. So we resent the papers in, and now I have to go check again one more time. But that's interesting, though, because I was, like, shocked looking in there. How could I not be in court? You know.
They called a name. No one appeared. Obviously, according to the record, you're not there. Failure to appear. Take it. The record has not been settled and closed. They waited 90 days to see if any external effects went in to close the record. Nothing closed it from outside, so they put out a capias, which is a show cause why you shouldn't be in contempt for failure to appear.
Well, the capias was already out before.
Before the 90 days?
Before the 90 days.
And they put it out after the straw man failed to have an agent show up at the case.
Mm-hmm.
They'll hold you if you're picked up and they identify you and the straw man as being one of the same.
So I have to go
That's
back.
why when going into court, you're the creditor. You have to help them resolve the matter. And certainly you can get on your constitutional and legal high horse and say, I'm not going to testify. I did that 15 years ago and was extremely successful at getting warrants out for my arrest, but nevertheless, when I went into court, usually when we went into court and did the things we did, they would eventually just drop the case or do something, but they at least want to test you a number of times and give you as much grief as they can until they find out what you're going to do.
I have a question on that part of going to court. Can you say, I'm here to represent so-and-so? You can't do that?
Not necessarily. There's many ways of saying, Your Honor, I don't have a name. I'm appearing here with regard to the matter of State of Ohio versus Smith. That would at least open a conversation. They may say, well, who are you? Straight out of Alice in Wonderland. And the whole issue is that living souls don't have names. They are known as.
Is it payer or payee? Which one?
No, they are known as. Scripture said that I knew you from the time that you were conceived in the womb. It didn't say you had a name. The name is what is christened in the little nautical ceremony, usually at the corporate church, where they break the bottle of champagne over the baby's head and sprinkle water on him and say your name is so-and-so. All they're doing is launching the vessel into commerce.
You can, before you go to court, can you put in to the record that you have a representative for you?
Whatever floats your boat. Caleb went along with me a couple of times when we put some paperwork in, and
Caleb ended up in jail too.
In jail, huh?
Caleb
I'll
did not end up in jail.
I did too end up in jail when I went with you.
Which time? You were probably beating someone up or somebody, Caleb, if you went to jail. It was probably because he always would never stand for the judge when he came in.
Yeah, no, they took us both over to county together.
Oh, on that was, which time was that? That was, yes, you did. I retract everything I said. I'm not arguing with Caleb at all. I can see I should not have raised that topic. I was thinking about my traffic cases. That had to do also with that foreclosure and stuff, but yeah, it was nice. You got to do solitary, if I remember. Yeah, and I didn't, and you were just a bystander. So I mean, there's your reversal. That's justice for you. The guy who's just along for the ride does solitary, and the other guy gets general population. But it's true they left you out quicker than they left me out, so that was justice. They left both of us out, actually. You had one day after solitary because they knew they couldn't hold you for anything, and they left me out in 3 days because I was under an investigation, and nobody ever knows why, but after the 72 hours of investigation, I was out of there for no apparent reason, so it worked. 72 hours is great. Yeah, you can do a lot of paperwork. The best thing was the last time you went with me, neither of us went to jail. We were out very quickly, and we settled the whole matter in one appearance. It actually took, almost about 40 minutes that the judge and I were discussing some issues, but then it settled and we were out of there. So we're doing better now. We're not going to jail anymore. Yes, we did. Yeah, we had a very good time for appearance on that one. Okay, I was asked to remind everybody, tail end of my cold, at least I'm not as bad as last week, my voice just sounds that way. Victoria's going to be doing a seminar in San Francisco, or just south of there, I believe, in Belmont, on October 24th through 26th. That's this coming weekend. She's going to be in San Antonio, Texas on November 7th through 9th. She is getting a lot of people coming to her seminars that are in deep trouble and in emergencies and panics when they have to know what to do right now. And if you people are anywhere close to the San Francisco seminar or San Antonio, Texas, go before you get in a panic and get into trouble and learn how to prevent these things. That's actually going to be the last of Victoria's seminars for the 2003 year. Presumably there will be a number of them set up sometime in 2004, but she is doing an excellent job of teaching people how to resolve problems so that you don't have these capiases out for your arrest and everything else. That's usually what happens, that people get an emergency. They've just been arrested. Now they're in jail on a warrant or a capias. You can't go to seminars when you're sitting in jail. It's very hard to send your friends or your spouses to the seminars when you're in jail and get all the information that you need to have, because even when they get the information and come home, you're not going to get it in jail that easily. So go learn to do things right to begin with. Victoria's got some great feedback on a lot of the people she's helping, the things that are happening to the people that have shown up to her seminars that are using this material, so get with the program. I've had a couple of emails that I will go over this evening. A couple of them are interesting. How many people in here do not know who Lynn Meredith is? Several hands. Lynn Meredith has been around the Patriot movement for quite a while. I believe she's from the California area. She has written at least one book dealing with, was it Legal Eagles or Eagles and Vultures? Vultures and Eagles Clothing. About the government, she has taken an anti-tax stand, pretty much an anti-government, i.e. government is doing everything wrong stand under the law, and we need to get our government back in line stand. I have chatted with her a number of times. She lost her husband here about a year and a half ago, I believe. The government once again invaded her home, attacked her, charged her with a number of issues, including taxes and stuff. And it's turned out that in one of the arrests and detainer, she alleged that the government, the California law enforcement agents exceeded their power, that they were authorized in some of their search and seizures and stuff, and she's had them in a court case. And the email that I got is a current decision that's come out of the Ninth Circuit, United States District Court of Appeals here on September 8th of this year, 2003. And she sees it as a victory. And in fact, for what she and her friends are doing, this is a good decision. Still, it's one involving where she is charging law enforcement agents. But I will let the decision kind of speak for itself, because the court is on a narrow decision here on the United States Court of Appeals that has basically stated that it reaffirms a lower district court decision where the government tried to move to dismiss liability charges against these IRS agents on the grounds of immunity defenses. And the lower court ruled that, at least as it relates to this one particular defendant, who is, I believe, the head guy in the IRS raiding party, that he has not got an immunity defense and that he will go to trial. And so I will read the brief decision of that court and probably discuss a couple of the issues. This is on appeal from the United States District Court for the Central District of California. And it deals not with the whole case, but just on the issue of that one summary judgment issue of denying immunity to a federal government employee. Lynn Meredith is one of a number of people that are the petitioners in this particular case. Facts are stated as following in the decision. ERAF and 12 other IRS agents entered the Sunset Beach property on July 10, 1998 to search for evidence in an IRS case. Upon entering the third floor, ERAF and some of the other agents encountered Bybee, who unbeknownst to them was using that floor as her residence. According to Bybee, she loudly told the agents that the search was illegal and asked ERAF to see a search warrant. ERAF did not provide her with the warrant because it had been left in the car. Bybee alleges that when she repeated her request to see a search warrant, ERAF grabbed her by her arms, forcibly threw her to the ground, and twisting her arms, placed handcuffs on her wrists. She further alleges that the handcuffs were closed around her wrists so tightly that they caused her pain, and that she suffered extensive bruising by the force used against her. After placing the handcuffs on Bybee, ERAF made her sit on a nearby couch and the search proceeded. Bybee states that she complained several times that the handcuffs were too tight and were causing her pain. But for 30 minutes they were left as they were. Thereafter, they were loosened so that they would not cause pain, but would nonetheless restrain her. The handcuffs were removed several hours later, and Bybee was told she could leave. She did not leave, choosing instead to remain on the Sunset Beach property until about 4 p.m. During this time, she sat on the couch and read a book. Following these events, the present lawsuit was filed. Although there are several plaintiffs, only Bybee is involved in this appeal. We first consider Bybee's claim that Agent ERAF used excessive force in handcuffing her. In Graham v. Connor, 490 U.S. 386 and 388, the Supreme Court held that, quote, the use of excessive force is contrary to the Fourth Amendment if it is excessive under the objective standards of reasonableness, not subjective standards. See Saucier, 533 U.S. at 201 and 202. This standard requires us to balance the amount of force applied against the need for that force. Diorl versus Rutherford, 278, Fed 3rd, 1272, a Ninth Circuit 2001 decision. In determining the need for force, we pay, quote, careful attention to the facts and circumstances of the particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or not, and whether the suspect is actively resisting arrest or attempting to evade arrest by flight, unquote. See Graham, 490 U.S. at 396. See also Santos versus Gates, 287, Fed 3rd at 846. Taking the facts in the light most favorable to Bybee. Remember, Bybee is the petitioner. And on any summary judgment motion to dismiss, the facts must be taken favorable to the petitioning party, not to the defending party. That's the rules for summary judgment. So taking the facts as alluded to by Bybee, a reasonable jury could find that Agent Erath used an unreasonable amount of force in handcuffing her and as a result violated her Fourth Amendment rights. According to Bibby, Erath grabbed her by her arms, forcibly threw her to the ground, and twisting her arms, handcuffed her. Erath did all of this after Bibby loudly asked several times to see a search warrant. Bibby did not pose a safety risk, and she did not make any attempt to leave the Sunset Beach property. Erath was investigating income tax-related crimes, which, although felonies, are non-violent offenses. Bibby objected vociferously to the search, and she passively resisted the handcuffing. But the need for force, if any, was minimal at best. In these circumstances, it was objectively unreasonable and a violation of the Fourth Amendment for Erath to grab Bibby by the arm, throw her to the ground, and twist her arms while handcuffing her. ID, the case Liston versus County of Riverside, 120 F. 3rd, 995, a Ninth Circuit 1997 case. When these events occurred, July 10, 1998, it was clearly established that the amount of force Bibby says Erath used in handcuffing her was excessive, and a reasonable agent in Erath's position would have known that such conduct violated the Fourth Amendment. See E.G. Hansen versus Black, 885 F. 2nd, 642 at 645, where it said the officers used excessive force on Hansen by unreasonably injuring her wrist and arm as they handcuffed her, unquote. Agent Erath, therefore, is not entitled to a qualified immunity on summary judgment as to Bibby's excessive force claim. Conclusion. The district court correctly determined that Agent Erath is not entitled to qualified immunity on summary judgment as to Bibby's excessive force claim. The district court also correctly determined that Agent Erath is not entitled to qualified immunity on summary judgment as to Bibby's claim that she was unlawfully detained for 30 minutes in overly tight handcuffs that caused her pain. As to these claims, we affirm the district court's summary judgment denying Agent Erath qualified immunity. So obviously the appellee in that particular suit was Agent Erath. Now notice there was no other discussions of anything going on necessarily in that case, and I'm not going to comment on anything else going on in that case. It's very carefully that was centered on the use of excessive force. There is no discussion about whether or not they were there and showed a warrant, didn't have a warrant, didn't have probable cause. Those issues are not involved in this decision. And in fact, I'm not so sure what the rest of the suit, the petition and the claims are in that case and how well it's going, but obviously the case has been held up on this appeal. It can now be remanded back down and proceed in whatever capacity. There was another email that I got from one of the people that gets our Monday night tapes. And these particular people, good friends of mine, have very definitely been following what we have talked about in terms of counsel of choice. And having that counsel appointed or in that courtroom during conditions of criminal proceedings. And this party emailed me a copy of a current Westlaw citation on a United States Court of Appeals Ninth Circuit Court case. This was filed on, the decision was filed October 6, 2003, so it just came out a week or so ago. It was argued and submitted on January 14, 2003 to the appellate court. And the petitioner in this particular case was a Henry Lee Cordova, who was the gentleman who was being criminally charged. And the case was in a state court. He went through the state court criminal proceedings, and we'll go through some of this because I think there's some important things in here you people have to be aware of as far as what the feds will do to protect rights even when state courts don't have legal counsel there for defendants. Because remember, I have been telling you that the Supreme Court has said in many cases that if in any criminal case, particularly one involving jail, if there is absolutely no counsel offered or there or waived intelligently by the defendant or the living soul representing the defendant, that there can be absolutely no jail time. And the Supreme Court of the United States has said that many times. Now, how do you get your remedy if the state courts or the federal courts don't abide by those conditions? And that's what this Henry Lee Cordova petition is all about. So he petitioned the United States Court of Appeals for the Ninth Circuit, that's out in the western states, the California area, and it's an appeal from the United States District Court for the Central District of California. There is actually, I think there was an attorney that argued for Cordova, in this federal court case, which is interesting. Okay. Opinion by Kaczynski, Circuit Judge. We must evaluate under AEDPA. I know everybody's going to say, what the heck is an AEDPA? Well, it's in here. It's encoded in the United States statutes as 28 U.S.C. Section 2254, subparen D, subparen 1. We must evaluate under AEDPA a state court's decision to apply harmless error review where a criminal defendant was not represented by counsel at trial following a defective waiver of his right to counsel. What have we been talking about? They don't appoint a counsel. You're a defendant in a criminal case, local, state, federal, international. There's a problem if you didn't waive it. Facts. Petitioner Henry Cordova was arrested outside his home after an altercation involving his neighbors. It gets actually funny now. He was handcuffed by a deputy sheriff and placed in the back seat of a patrol car. After the deputy entered the car and sat in the driver's seat, Cordova either sneezed or spit, depending on whose story you believe. As a result of which, something unsavory landed on the deputy's face. Now, I feel sorry for the deputy, but let me tell you, Caleb, you've admitted it. When they put you in the back seat of a patrol car, many times aren't you in handcuffs with your hands behind your back? And it's very difficult to turn, change position, or do anything. And man, if you got a sneeze, There's no way you can politely put anything in front of you because they've restrained you from putting anything in front of you other than a fence between you and the stupid officer who's staring in your face. Cordova was charged in the South Bay Municipal Court with 3 misdemeanor counts of battery, 2 on his neighbors, and a 3rd on the deputy. I told you it's going to get even better. He's going to be found innocent of the 2 charges on the neighbors and guilty of the one on the deputy. Now, go figure. Why would he be in the car to begin with? Only because of what he allegedly did to the neighbors, okay? Cordova was not eligible for representation by the public defender. You think that's going to make a difference? Don't make one bit of difference. Nope. We got a guy who keeps calling me up and he goes, hey man, he says, I already informed the prosecutor and the judge that it appears as though they've got a petition or they've got to appoint counsel for the defendant. Well, remember, this is the case I talked to you about in which there was a public defender, but it appears as though 2 months ago the guy decided that he was going to represent himself. So they discharged the public defender. So when he decided to start being intelligent and he petitioned the court for counsel for the defendant or advised them that that would probably be a good idea, the judge is playing really stupid. He's not stupid, he's playing stupid. And all of the documents which are going in by private letter rogatory have responses coming out of the judge's chamber by private response letters. Nothing's in the public. What goes in comes out. Private going in, private coming out. So the judge came back on the first notice and said, gee, I'm really confused here. I don't know whether the defendant wants to represent himself or whether he wants counsel. And so the guy getting that document privately out of the judge accepted it for value, returned it for value, put it back with notices to the other parties saying that he really didn't think it was his position, since he's not an officer of the court, to make those determinations. However, he knows that, he said by negative averment, I don't believe I'm an officer of the court. I don't believe I can represent the defendant. I don't believe I have standing to come in and do any of this thing. I don't believe the defendant's represented by anyone. So the judge comes back again by a private response and sends him a handmade questionnaire with 4 questions to fill out now. And he goes, well, it appears as though this guy is asking for us to appoint someone. But then he hasn't gone down and applied for indigent counsel, and so the judge had like 4 questions. Do you, as the defendant, want to represent yourself? Do you want the court to appoint someone? Are you whatever? So I said, well, if that was me, I wouldn't just check the boxes and put down below. I just accept it for value, return it for value, and say this is a questionnaire which needs to be filled out by the counsel for the defendant, and still haven't seen where he's appointed. So anyway, this guy is very scared that they're going to arrest him and hold him in contempt, because he said once before when he filed stuff in the clerk's office, they arrested him for contempt for putting documents in the case. I said, well, thank goodness you're just sending private notices to the parties, because I don't think there was any order not to send private letters rogatory to anyone, and that's a very good reason why the defendant probably needs to have a counsel. So they're going, in fact, I think he should have had a hearing maybe this week in which he's got to show up and we'll see what they do. But it's funny that when you request or when you point out to them that they need to set the court properly with an attorney to represent the defendant, then all of a sudden they keep testing you to see if you are going to try to do things for that defendant as though you yourself are representing him or bringing or moving the court in his behalf to do these things. So, okay, here is this guy. He was not eligible for representation by the public defender, and he vacillated as to whether he would hire a lawyer or represent himself. To leave this for a second again, the other guy said, well, what if they want me to go down and look at a public defender and fill out any requirements? I said, well, just tell the court that you are the party that has been involved in terms of underwriting the surety for the defendant, the aggrieved party, but you're not the defendant, and you can't make determinations to represent the defendant. But if the court goes ahead and appoints an attorney, you will be more than happy to accept any liabilities that the attorney may turn in as liabilities belonging to the defendant, and accept those so that they can be adjusted and set off by way of the exemption, because you don't want to cheat the lawyer. And he's entitled to whatever obligations the straw man might have, and I'll write that off along with all the other liabilities that I'll be happy to take care of. So he goes on. The trial judge, and everybody agrees, did not admonish Mr. Cordova as required by the case of Peretta versus California, which is the basic case, 422 U.S. 806, which is a 1975 case. Everybody's got to be represented by an attorney. That case held that a criminal defendant wanting to represent himself, quote, should be made aware of the dangers and disadvantages of self-representation, so that the record will establish that he knows what he is doing and his choice is made with eyes open, unclosed. Or any parentheses. With his eyes open. Okay? Very simple. They got to admonish him, make sure that he's intelligently making that decision. Now, understand Mr. Cordova in this case, you're going to see went on and represented himself, notwithstanding. But he was never even admonished by the judge in the open court as to the standard. Cordova ended up representing himself. After a jury trial, he was acquitted of the 2 counts involving his neighbors, but was convicted of battery on the deputy. The appellate division of the Los Angeles County Superior Court affirmed the conviction, even though it found that, quote, the trial court committed error in failing to adequately advise Cordova of the dangers of self-representation, unquote. And the record was therefore, quote, inadequate to demonstrate that appellant was sufficiently informed of the dangers of self-representation as to make an intelligent and knowing waiver, unquote. See appellate division order at paragraph 7. The appellate division, however, found that, quote, the failure to advise the appellant of the dangers of self-representation was harmless beyond a reasonable doubt, unquote. Under the alleged Chapman versus California decision of 1967 that was reported at 386 U.S. 18, it said, because, quote, there is nothing in the record to support a finding that the results would have been any different if appellant had been represented by counsel, unquote. In other words, a lot of times if you're on appeal and you're going to get a reversal, you've got to not only have a reason for why they should reverse, but you also have to have a plausible explanation that if the court actually applies your request for reversal, that there would be something different in terms of what could be brought, what could be argued, what could be used as a defense, if we do it all over again with whatever it is that we've got to do right this time, so that it's not a complete waste of the court's time just going through the motions of doing it over again. That was the issue that the California Appellate Division used. The case did not involve a sophisticated defense or complicated legal issues, the appellate court in California said. It was simply a question of who would the jury believe. The police officer sitting in the front seat, who claims he was spit on, or the prisoner with his arms behind his back looking him straight in the face because he can't move in the back seat who said he sneezed.